good noon, everybody. Thanks for joining us. I know there's a lot to talk about around SORA reform, and there are a ton of questions. So I wanted to just quickly say a few things. First of all, the reason that we've set up this webinar so that the interaction is not audio, it's all in the chat, is because there's been a lot of trolling of these webinars lately, people putting porn on the webinars, so we really wanted to avoid that. So I'm sorry to make it kind of this type of non-interactive, but it's the best thing we can do to make sure we don't get interrupted. So we've got a pretty ambitious agenda today, and we're gonna go through introducing you to the panel. We're gonna have a little legislative update. We're gonna have a legal update. And then we're gonna talk about the plan to build a campaign over the next 6 months so that we can use this time when our legislators are stuck at home to educate them on the reason that we need real reform for SORA. And we've got a plan to build a campaign that involves about 10 to 15 volunteer leaders and groups of volunteers in a kind of geographically across the state. So we'll get into that a little bit. And then we'll talk about next steps, and then we'll open it up for questions and answers. You'll see on the screen as we go along that we'll have the agenda up on the screen, but we'll also have contact information on the screen for the various organizations that are with us today on this call. Contact information for when you have questions about a specific case, emails, phone numbers, and then we'll have, for those people who can't use the internet as much, we'll have a phone number that you can text to with some of these questions. So what I'd like to do, first of all, is to introduce the panel, let them tell you who they are, and then we'll do a quick legislative update, and then Paul Reingold will talk to us about the legal conundrum we're in, I guess, but he'll give us an update on that. So has Barb joined yet?
I have.
Oh, great. Okay. So we've got, I'd like to start by introducing Tim. Many of you know Tim from the ACLU office. Tim, can you introduce yourself?
Yes, good afternoon. I'm Tim from the ACLU, and I'm the ACLU of Michigan's SOI specialist and have been working with them for about 10 years. I've been involved with this issue since 1994. At the ACLU, we maintain a list of people who would like to come to testify before a committee of the House or Senate. We do understand that that's not for everyone, of course, but if it's not for you, today we are going to give you other opportunities to get involved and stay involved. The ACLU cannot do this alone. Also, if you aren't a member of one of the great groups that we're working with, join them or join us, and we'll work together to keep you informed. You can contact us, and for those people that will see it on the internet, but those that are on phone, you can contact us at intern@aclumichigan.org or call us at 517-372-8503. Leave a message. We will get back to you, and this may take a little bit longer on the phone. This process will not end with the stopping of this bad bill, and we can stop it with your help. Just like the one we stopped in 2010 that the state was proposing, and it was a much worse bill than the 2011 law we passed. We need your help now, and when we leave, have this a bill that we can support. We'll also need your help. Get involved, stay involved. Thank you, Shelley.
Thanks, Tim. Barb, would you like to introduce yourself? You're muted, Barb.
Yeah, I'm challenged too. My name is Barb, and I am on the steering committee for the Coalition for a Useful Registry. And I have been an advocate actually since 2000, but started with the coalition in the coalition started in 2006. and advocating for changes to Michigan's registry. The coalition also has a professional advisory board that is a multidisciplinary group of, I believe, around 33 professionals who have been very instrumental in helping us advocate for change. And I think, yeah, my email's right on there.
Thank you, Barb.
Thanks.
John and Kathy, you can go together or separate, however you want to do it.
John's going to speak for both of us right now.
Yeah, Kathy and I are here representing Michigan Citizens for Justice. It's a peer-led support and advocacy group for people who are forced to register, as well as their family members and friends. As a support group, we have 3 active chapters, one in Ann Arbor, one in Kalamazoo, and one in Port Huron. And we keep regular contact with about 200 people around the state. Not everybody in the group is has enough emotional energy to do more than just fight the roadblocks and the stigma of the registry, but some do. And for those of us who do, we have an advocacy subgroup that has been lobbying the state legislature for changes to the Michigan SORA for over 2 years now. We've contacted every representative and senator's office with flyers, and we've had about 40 face-to-face meetings. And we're going to mobilize one more time to fight this new bill that this introduced into the state house.
And if you want to contact us, you can go to micitizensforjustice.com. There's information about contacting each of the 3 support groups, so that's the best way.
Thank you. Greg Kelly?
Hi, good morning. Hi, good morning. My name is Greg. I'm a registrant and been on the list for since 2007 in Macomb County. So if there's folks out there that want to reach me, you could call the ACLU office there in Lansing at 517-372-8503 and just leave a message, and they'll get your phone number over to me, and I'll be glad to talk with you. So, we really appreciate your help in trying to get reform and get something, get this awful legislation turned around. Thank you.
Thanks, Greg. Kay Perry.
Hello, my name is Kay Perry. I am with Michigan Cure, which is sometimes called My Cure. It's a grassroots criminal justice reform organization statewide that's been around since 1989, actually, and I've been associated with it for all that time. This is an issue that has concerned us all along, so we're very interested in what needs to be done to get us a law that we can all live with. My contact information is there on the screen. Thank you.
Thanks, Kay. And we'll make sure all this contact information is on our website as well. So I want to talk for a few minutes about the, a legislative update. And to remind everybody, if you have a question, I'm seeing a lot of questions in the chat. You really want to put those questions in the Q&A.
Shelley?
Yes. Oh, Josh, I'm so sorry. Sorry, Josh. I apologize. Josh, go ahead.
I'm Josh O. I'm formerly incarcerated activist who's on the registry. I'm also a policy analyst at Safe and Just Michigan and the host of the Decarceration Nation podcast, where we try to cover all areas of criminal punishment system, including registries. I've been on the registry since 2010, and I primarily do legislative work now. Thanks.
Thanks, Josh, and I do apologize. So let me go into, so again, if you have questions, please put them in the Q&A as much as you can, so we can make sure we have everything we want to answer at the end of the webinar. So most of you know, Paul will talk about the legal timeline and how that will affect our legislation, but most of you know that we've been working for at least 3 years on trying to get some reform legislation to address the Doe 1 and Doe 2 cases. And we've come to some great agreements with the people around the table, the prosecutors and the AG and the governor's office, but unfortunately that has all fallen by the wayside. Frankly, when the new governor took over, I think she just wasn't really as interested in fixing this as the previous administration was. But because the lawsuit has been moving along, we now have a bill that's been introduced. It's 5679, I think. Now all of a sudden I can't remember the bill number. Oh yeah, 5679, and it's been introduced in the House, and it was introduced to address the lawsuit, to fix the constitutional issues with the lawsuit. It is not a bill that we support at all. It does not incorporate any of the changes we agreed to in all those 3 years that we worked together. So even with the courts telling the lawmakers that they have an unconstitutional law, that they have a flawed law, there is no political will to change it. So just to let you know a little bit about 5679, and it's also on our website, it would effectively split the registry into one registry for pre-2011 offenders and another for post-2011 offenders. It does not eliminate the buffer zones for living and working, and it puts various rules in place for registrants who are going onto school property. It does not provide a path off the registry. It does not reduce the 25 years and the lifetime registration requirements. It does not exempt HIDA, the Homes Useful Trainee Act recipients, nor does it exempt those with expunged records. So the bill basically has nothing in it that we think is worth supporting. And Paul will talk more about how he thinks that bill measures up in terms of its the constitutional issues it was supposed to address. So our goal in this campaign is going to be to just make sure that 5679 never sees the light of day. We are in absent the ability to repeal this registry law altogether, which I think none of us think is going to happen. That would be our goal, but we don't think it's going to happen. We would prefer and want to promote legislation that incorporates the recent American Law Institute model policy. And that too is on our website. The American Law Institute is a national organization that develops, policy for all the states to share. So the policy is very robust. There's a lot of in the document itself. There's a lot of great research in there, and I encourage people to take the time to read all 300 pages. But for the most part, the policy itself makes the registry a law enforcement only registry, so what we would call a private registry. It has a 15-year maximum with the ability to petition for relief at any time during those 15 years, but automatic relief at 10 years if the person is free of violations and has completed whatever work they were supposed to complete in terms of classes or anything. It does not include juveniles. It's limited to 6 categories of registerable offenses, and that can be tricky, but it is that the offenses are much more narrow than the Michigan law currently allows. It has an annual verification requirement with other necessary information being updated by mail, phone, or the internet. So it does require people to still come in once a year. And it limits government-imposed additional collateral consequences, such as the buffer zones and inability to work in certain places. So this is the bill that we think we could support, and these are the policies that we would want to promote in our campaign. Again, absent just getting rid of the registry altogether. We don't know the fate of the current of 5679 because they introduced it, when they introduced it, to his credit, the chair of the House Judiciary, Graham Filler, let us know that he intended to have a very full and robust hearing on the bill, that he did not want it just to pass under the, cloak of darkness. And he wanted us to bring professionals to these hearings, professionals, researchers, and especially impacted community members and their families who, had to suffer under the consequences of this registry all these years. Now, at this point, it's, we think it's unlikely the legislature is coming back for anything other than emergencies over the rest of the session. So we just don't know what to tell you about the fate of that bill. But at the very least, we have a commitment from the Judiciary Chair that he's not going to try to just slip it in when nobody's looking. So at this point, I would like to turn the webinar over to Paul Reingold, who is going to talk to you about the where we are on the Doe's and Doe's 2 case.
Hi, I'm Paul Reingold. I teach at the University of Michigan Law School, and I've been co-counsel with the ACLU and a private lawyer on the Doe's 2 case. Miriam Ackerman is the lead counsel in the case from the ACLU, and Allison Oliver of the Oliver Law Firm is the private lawyer who's helping us out. I'm going to give you a little bit of history just sort of to bring everyone up to speed, but I'll focus my remarks on what's happening now and where we're at. As most of you know, the Doe's 1 litigation was intended to be a global challenge to Michigan's SORA. Miriam and I worked on that case from 2011 until 2017, and we got very strong opinions both from the Federal District Court in Detroit and from the Sixth Circuit Court of Appeals in Cincinnati. In the Doe's 1 case, the major holdings were from the Sixth Circuit, which held that the 2006, those are the school zones, and the 2011 amendments, which were the major changes that brought Michigan's SORA into conformity with the federal SORNA, created the tiers, increased the penalties, made the public registry much longer, and converted most people to Tier 3 lifetime registrants. The court held that those 2 amendments were unconstitutional under the ex post facto clause because cumulatively, taken as a whole, they rose to the level of punishment. The ex post facto clause says you can't punish people after the fact, after they've committed a crime. And so retroactively, if you increase the punishment, you're violating the ex post facto clause. What that meant was anybody whose crime occurred before 2011, before the amendments passed in 2011, we thought was going to be protected. The district court also held that certain parts of the statute are vague or violate the First Amendment, and it held that the overall statute is vague enough that it can't be enforced as a strict liability statute, which parts of it had been. Strict liability simply means it's like having a driver's license. If you get stopped and you don't have your license with you, you can be charged with a crime. And SORA was interpreted the same way. The judge said no. The judge said it's vague enough and hard enough to enforce that we're only going to allow enforcement for knowing violations. So those were the holdings of the 2 courts. When in 2017, when Doe's 1 was over, we assumed, and the state told us, that it was going to pass a new law to cure the constitutional defects. The state kind of dragged its feet, and we waited and waited, and eventually it was clear they weren't going to do it. And in fact, the AG's office took the position that Doe's 1 only applied to the 6 named plaintiffs in the case. So Miriam and I said, well, okay, we spent 6 years, but we haven't actually accomplished anything yet for registrants. So together with Allison Oliver, we filed a new class action, basically seeking to enforce exactly what the two courts had done in Doe's 1 for everybody on the registry. We filed that case and then kind of put it on hold because it looked like the state was interested in negotiating a new statute. We got class certification, the court certified classes and entered some declaratory relief, and it gave us a chance to negotiate. And the negotiations in 2018 and 19 actually moved pretty well. And we were optimistic in the summer of 2019 that we weren't that far from an agreement. And then we think under the direction of the new executive administration in Michigan, the executive departments pulled out of the negotiations in August. They just sort of shut the door. So we went back to court. And when we went back to court, we had to now brief and argue all of the pending motions. That occurred in late 2019 and in early 2020. And then, as most of you know, on Valentine's Day, on February 14th, 2020, the court finally issued its decision. The decision was basically a total victory for registrants. The court held specifically that the 2006 and 2011 amendments are punishment and can't be applied to anyone whose registrable offense occurred before those amendments took effect. You should understand those amendments can still be applied prospectively because as long as when the crime occurred, people knew what they were going to be subjected to, there's no ex post facto violation. And so anyone whose registrable offense is after April 12th or April 11th, I guess it was, 2011, can still be subject to the current SORA. The court also held that the unconstitutional parts of SORA that the district court had said in Doe's 1 were unconstitutional remain unconstitutional for the entire class, for all registrants. That's the vagueness stuff, the First Amendment stuff, and the strict liability part of the statute. The court's opinion, instead of, normally a court's opinion would say, I'm entering this relief, holding these things to be unconstitutional and issuing an immediate injunction. And the injunction would bar the enforcement of the statute, usually on the day that the judgment entered. What Judge Cleland did in the case is say, I'm going to give the legislature 60 days after the judgment enters so that they'll have one last chance to pass a new law if they wish to do so. And if they don't, then the injunctions will take effect. It actually gave the legislature, it would have given the legislature probably 75 to 90 days because the court gave the parties about a month to get a final judgment entered. So it would have been about 30 days to enter the judgment and then 60 days more before the injunctions took effect. One other piece that the court decided that was critical was that the parts of the statute that violate the ex post facto clause, the 2006 and 2011 amendments, are so embedded in the law that the unconstitutional parts can't be cut out. The legal term is they can't be severed from the statute and leave anything intelligible. And what that means is the court held that when the injunctions take effect, the entirety of SORA, not just the 2006 and 2011 amendments, can't be applied retroactively. And so as to the ex post facto subclass, there is literally, or there would be when the injunctions take effect, literally no law on the books that applies to them. All right, so the parties went to work to get the final judgment done by March 13th. It was a month. And we got close, but there were some unfinished details. And so we asked the court for a week's delay, which the court granted us. Unfortunately, between March 13th and March 20th, when we were supposed to be back in front of the judge, the COVID-19 crisis had emerged full blown. And it was crystal clear that government was not going to be functioned normally, and that all of our lives were going to be changed in a fairly radical way. In the meantime, the Michigan State Police had, I think the Attorney General's office would say, misread the court's order and thought that they should stop registering people in the ex post facto subclass immediately, even though the injunctions were not going to take effect for 90 days. And so in February and March, lots of people who went to register were told, if your offense was before 2011, you don't need to register anymore. Then the word got out to everybody, the police aren't registering people. And so even people whose offenses were after 2011 weren't necessarily going down. And everybody had questions, what do we do? What do we do? All right, so we go back to court on March 20th, and the judge says, we clearly can't go forward. The legislature can't meet. There can't be committee hearings. No one knows what to do. We have to put this case on hold. What the judge wanted from the parties was proposed orders that the court would enter, delaying entry of the judgment, delaying the effective date of the injunctions. And so both sides submitted orders. The state's order simply said the case will be held in abeyance, period. So it would simply delay everything. Our response on behalf of the plaintiffs and the classes was, that's crazy. We've created a law that says you must register, and if you fail to register, you're guilty of a crime. And the governor has just entered executive orders that say, if you go out on the street, except for certain purposes, you're also committing a crime. And so our view was the two laws, one an executive order and the other SORA, put registrants in an impossible situation. Our position was also that the last thing we want is people going out on the street for any reason, right? The whole point of the executive orders, the healthcare orders, is to keep people from being around each other. So it made no sense for people to be trying to get to police stations and other registration centers to register. So what we asked the court to do was, yes, delay the whole case, but enter injunctions that make it really clear that no one can be prosecuted after the fact for failing to register during the period of the crisis. We also argued to the court that everybody's going to be getting sick, and the last thing we want is for people not to be able, for example, to get tested in a portable testing site that's within a school zone, because you'd be loitering within the school zone, and that doesn't make any sense. Same thing if people have to be hospitalized. If the hospital is within a school zone, technically you're violating SORA. So we asked the judge to enter interim emergency relief in the form of a preliminary injunction that would simply make clear that nobody could be prosecuted for failure to register, failure to verify, entry into a school zone during the crisis, or failure to pay fees. Those orders went to the court on Monday. We thought we would have an order from the court within a day or two. We have not heard anything. I just checked moments ago and still don't see an order having been filed, and it's impossible to say what that means. An order will enter soon. I don't know if it'll be by the end of today or Monday or Tuesday or Wednesday, but we know that the judge is working on it. It's hard to read anything into the delay. So at this point, we don't know what the court is going to do. If the court simply enters the state's version of the order or something like it and no protection, it means people aren't going to know what to do. Our recommendation has been to people, try to register or call ahead and say, if we come down, will we be able to register? If you're told, no, the police station is closed, we don't want you to come down, get the name of the person who told you that, write it down, get the date so that you're protected later if a prosecutor tries to prosecute you for failure to register. If, on the other hand, the judge enters the protective order that we're hoping he will enter, then everybody's off the hook for the duration. And then as soon as we come out of the pandemic and the executive orders, the emergency orders from the executive start to be unwound, there'll be notice to registrants saying, here's what you now must pick up doing, which will probably be to continue to do what you were doing before, because there's still going to be a delay before the final judgment gets entered, and then there's still going to be another 60 days before the deadline on the legislature. So our advice to people is make the effort now, document what you're doing. If you get down there and they say no, get something in writing if you can. If you call in, get the name of somebody, write down the date and so on, and keep doing that so that you can show good faith efforts to comply. What we argued to the judge was, the judge's reaction first and opposing counsel's reaction was, why would anyone prosecute after the fact? And we had two responses to that. One, we said, first, the state is unwilling to agree to this part of the order. They simply want the case delayed. And if they're unwilling to agree, that ought to be some indication that they think there's an ongoing legal obligation to register. So unless you fix that, that's going to be the state's position. We also argued that after DOES 1 and the initial orders in DOES 2, people still were being prosecuted around the state for violations of the parts of SORA that had been held to be unconstitutional. And we said, given that it happened in the past, it's likely to happen again. And so we think the added protection is necessary. I'll stop there, and I hope that's helpful and brings you up to date on where we're at.
Awesome. Thanks so much, Paul.
Thanks, Paul. There are a number of questions which we will get to. So in the meantime, we're going to talk about the potential campaign we're mounting, but I want to ask Kathy Gorley to talk to us for a few minutes about how to help impacted citizens tell their stories. Kathy?
Okay. I prepared a document that just gives some suggestions. It's good to know all the facts about what's going on when you want to talk to a legislator or someone in politics, but you can tell how the registry has hurt you personally, that moves them on a different level. They can see the effect of the loss. And everyone has many ways they've been hurt by the existing sex offender registry, whether it's been not to be able to attend events at your child's school, or losing a job because some coworker looked you up on the registry and refuses to work with you, and so your employer fires you, or maybe it's just that the offense was 25 years ago. You're no longer the person that you were. You were only 17 years old and now you're 50, something like that. So I prepared a document with a list of ideas of how you might have been affected, just to jog your memory. At the end of this, we're going to be asking people to volunteer to advocate against this Bill 5679 and for the things that Shelley mentioned, for either no registry or extremely reduced private registry. And everyone who volunteers will get a copy of this, and I'm also going to send out a copy of this document to everyone that's in Michigan Citizens for Justice.
Thanks, Kathy. I realized I forgot to introduce myself. I'm Shelley Weisberg. I'm the political director for the ACLU of Michigan, and I've been working on the sex offender registry for the whole time I've been there, which is close to 20 years.
Shelley, while I'm not muted, could you announce the phone number that people can text questions to, because that hasn't been given? Or can Jessica?
It has to be Jessica because I don't have it. So.
Yes, thanks. Thank you, Kathy, for flagging that. Well, hang on everyone while Shelley, why don't you give a cute, why don't you transition us while I pull up that phone number?
Great. So I wanted to talk a little bit about the plan of action over the next 6 months. And I know that many people on this webinar have been advocating all these years. I am not trying to ignore the fact that you've all been doing great work, but I think this is a prime time for us to all really move in one very solid direction. And so what we're proposing is to create a system of volunteer coordinators, basically by geographic region, that would then build their own volunteer teams. And these volunteer teams would be responsible for reaching out to the legislators in their geographic area. The ACLU can provide a lot of resources to build the skills and tactics for these volunteer teams, where we can bring in professionals to talk about the research. We've got a couple professionals who can really help people learn how to tell their stories better. We can do training, lobby training. We'll have templates for letters and for emails. And at this point, it's, we have to really think about what those geographic areas are, but for the most part, on the agenda, for those who have it, you'll see that we've kind of at least called out the areas where the members from both the House Judiciary and the Senate Judiciary committees are, because that's where the bills will go, where the members are, and that's Macomb County, Oakland County, Wayne, Kent, Washtenaw, and Ingham, and then northwest Michigan and the UP, and then central and eastern mid-Michigan. So at the very least, we need those geographic areas covered, and I think we'd be better off with about 15 volunteer coordinators to cover all of Michigan. So the goal is to have volunteer leaders willing to lead teams, to do outreach to the legislators, to engage in information sharing, which we will facilitate through a Google Docs system. That will have a tracker for all the legislators. It will have all the templates on it. And then we'll have training opportunities such as, team building and storytelling. We will have a variety of tactics people can use in this time to reach their legislators, including email and social media. And we'll have a system for feedback from the volunteers and the volunteer coordinators to make sure that we record everything and we can keep track of who we've reached out to, what the responses have been, how we've reached out to them, and the ways in which have been most successful. And so what we're going to be asking for, as Kathy mentioned, is people to volunteer to take that leadership role, and then our next step will be to work with the leaders to learn how to build their teams. And Jessica, are you with us, Jessica? Yeah. Jessica is our public engagement strategist, and I was hoping you could maybe walk through how we do that here at the ACLU, just to give people a sense of the support that can be provided.
Yeah, absolutely. But before I transition to that, I do want to flag for anyone who is just joining us via phone, there is a phone number that you can call or text questions to if you are just joining by phone. And that number is 313-451-2672. Again, that's 313-451-2672, and we'll repeat that a couple more times throughout the call. So don't feel pressured to memorize it right now. But yes, as Shelley said, my name is Jessica Ayub, and I am the public engagement strategist at the ACLU of Michigan, which means that I work with volunteers across the state to connect them to volunteer opportunities and provide them with trainings to make sure that they feel confident in the work that we're asking them to do, and that they have the support that they need from us to work on these very important issues. So there are, you know, a number of things that we can do to train volunteers and folks to advocate legislatively. And in this time of social distancing, we are working really to still foster relationships among volunteers with the ACLU. And so we have been doing a series of online trainings and like this one, webinars and trainings, and also phone-based trainings to really build the skills of folks to advocate for the policies that we are hoping to change. So that is, you know, that can include a messaging training, that can include a general legislative advocacy training. As Kathy mentioned, there could be a story sharing training, really a whole host of opportunities for you to really feel confident in the work that we're asking you to do, but then also to, you know, give you the skills to then pass that on and train your friends and family or other folks you know who are passionate about this issue as well. And so, as Shelley mentioned, what we're really looking to do is build strong geographic volunteer teams across the state, where we have dedicated volunteer leaders or captains who can serve as our eyes and ears to the rest of the volunteers. That volunteer coordinator will work really closely with me and Shelley and members of our legislative team to get a sense of what trainings your volunteers need, what numbers, I'm sorry, there are a bunch of chats coming in that are distracting me, what their folks on the ground need and how we can be most supportive and what trainings we want. We really want to offer you all trainings that that you are asking for and that you want and that you think would be helpful. And so I am just going to pause really quickly because lots of folks want the text number again. So I'm going to repeat that really quickly before I finish.
Jessica, can you put the text number in the chat, please?
I can.
So Kathy and John have already mentioned they've got a couple of people who are willing to be volunteers, and we'll be asking people who want to volunteer, either to be a volunteer leader or a volunteer. We'll be asking you to use that intern at ACLU email. This whole webinar is recorded and will be on our website, and we're about to go through the questions, and all of the questions will also be listed with answers on our website, because we won't be able to get to all of these questions. And specifically, people who are asking questions about a specific case, an individual case, we really asked you to go to the intern at ACLU-MISH.org email. That is, and Jessica, could you put that in the chat box too? Just, I know it's on the screen.
I can, and I am also gonna get to this last page. But what I want to do, Shelley, before we pivot to I want to pivot to what Shelley asked is, you know, we've been talking at y'all for a little bit now, and we would actually love to just get a sense of where folks are at.
I'm not sure I understand.
My watch is talking to me now. So we are going to launch a poll on your screen if you're joining by computer. And we want to see where y'all are at. So if you want to take action, let us know how you want to take action. There should be a poll on your screen, or you can text that number that we dropped in the chat box and let us know. Just click the answer that you are looking to do.
What How are they going to know? Does the chat, if they do it through the text, does the poll come up in the text?
They can just text me if you want to be a volunteer coordinator, if you
Oh, I
want to
see.
join a volunteer team, or if you would like to participate in a training.
Great. Okay, in the meantime, while that poll is launching, I'm going to go ahead and start going through these questions. Paul, many of them are going to be for you. Before I do, does anyone on the panel have anything they want to add at this point? You could just shake your head yes or no. Okay. Great. Okay. So the first question, the first one isn't really a question, but something we get a lot.
Hang on 1 second, Shelley. The poll is not, oh wait, there we go. The poll should have popped up on your screen. Let me try and do it again. Okay.
Oh, there it is. Okay.
There we go. Sorry, y'all.
Okay, so Paul, the first comment really is somebody who's from out of state and they were convicted in another state and currently living in Michigan. It's not a question, but we get this a lot. People want to know what their duties will be under our revised law, given that they were convicted in another state.
Yes, that was one of the issues we were dealing with in trying to figure out what the judgment was going to say. And the state was taking one position and we were taking another position, and I think we had it resolved. The way it works is if someone's registrable offense was from out of state, what Michigan has done is basically a 50-state survey where they look at all of the criminal laws in the other 49 states and then try to find the closest Michigan equivalent. And the closest Michigan equivalent is what then determines whether or not the person will have to register or what tier they'll be on in Michigan. So if the law changes, everything is up in the air. It's going to be, everything will hinge on the terms of the new law. And we simply don't know what that's going to be. And so it means some people could drop off, some people could come on. It could be better, it could be worse. So there's no quick and easy answer to that if you're coming from out of state and living in Michigan. If it's the reverse, if you're a Michigan person and going to another state, that state's laws apply. And those laws are all over the map. Some say if you had to register in Michigan, you must register in the other state, even if in the other state you don't have to register. But some are much more lenient. Even though you had to register in Michigan, you might not have to register in the other state. But we don't know the other state's laws well, and so for that, you need to find a lawyer in the state you're going to.
Another common question we get is if somebody's convicted under federal law and serves time in a federal prison, how does that affect them under state law? Paul.
Yeah, that's a great question. It's one that's being litigated right now. There was a guy in Michigan who had not been convicted under federal law. He had a Michigan conviction, and he was afraid that he might be charged under federal law if he dropped off the registry in Michigan. And so he filed a lawsuit preemptively to try to prevent that from happening. The state defendants settled and said, yes, you've got your 25 years in, you no longer have to register. But he also sued the U.S. Attorney General, and the federal defense of the case said, oh, no, you still must register. And he lost that claim in the federal district court. It's now on appeal in the Sixth Circuit in Cincinnati. Miriam and I filed an amicus brief on the case. We think that if you've committed a state-only offense and you don't engage in interstate travel, that is, if you don't put yourself into federal commerce, as it were, we think that the federal SORA can't make you register under state law. But it's not a claim that's been decided yet within the Sixth Circuit, and it might be that it loses. If it loses, we don't really know how people do it because, for example, the plaintiff in that case, if he's been told you no longer have to register under Michigan's registry, and then the Sixth Circuit rules, but you must register in Michigan under SORA, the federal law, we don't know how he does that because when he goes to the Michigan registry, they're going to tell him, you don't have to register. You're not on this. And if he is made to register, then it's going to make him look like he's still on the register when he isn't. And so we don't see a way out of it practically that you can be liable for registering if you have a state violation that expires and the feds try to make you register. One quick follow-up. The question was, what if you have a federal conviction? If you have a federal conviction, then you are obligated to register based on the federal conviction in whatever state is your, you would have a registrable, you'd have the duty to register under federal law. And that's usually your home state or where you work or go to school. And so in that case, the answer would be yes, you do have a duty.
The glitch is, Paul, like if for instance, if Michigan can get rid of the registry, there is no federal process for registering other than through the states.
That's right. The only federal registry is a compilation of all the state registries. Okay. And so it's not an active registry. You can't go there and change data on it. It's simply they're importing data from the states periodically. And so people might come on and come off, but it's because they've come on or come off the cumulative states registry. That's right.
Perhaps this next question, I think you can probably get rid of pretty quickly, but so this says, they're asking how the lawsuit affects, the ruling affects pre-1999 and 1994 offenses as though they were different subclasses. So I think this person is thinking that those are separate subclasses.
Yeah, they're not separate subclasses. The subclasses were pre-2006, pre-2011, and post-2011. And because of the severability issue, the judge basically lumped the 2006 and 2011 groups together and said, as to everybody who is before 2011, because the unconstitutional parts of the statute are not severable, the entire SORA, if we get to the injunctions, will be stricken as to them. So if the legislature does nothing and doesn't pass a stopgap bill of any kind, at some point, the injunctions will kick in and SORA will not exist for the pre-2011 people.
This is another question that I think is worth you looking at. They're concerned that the legislature could seek to re-sentence people who, under these new laws, that the legislature could, re-sentence people. So maybe you could clear up that a little bit.
Yeah, the legislature doesn't have the power to sentence. Only the judiciary has the sentencing power. The legislature can, the law that they have introduced in the House is basically SORA minus a few provisions, and nothing much would change. We think it's a horrible law. It goes against all of the modern social science research and all of anything smart modern policy. It's a waste of the legislature's time and our time, frankly. But beyond that, it's the new law that's going to govern. There's one other question I can answer about the new law. People want to know, how will you find out about the new law, and how will you find out about what's going to happen in the interim, the 90-day period before the injunctions take effect, or even what happens after the injunctions take effect. And the short answer to that is, once the judgment is entered at the end of the COVID-19 crisis, there will be individual notice. The state will be sending 44,000 letters to people saying, here's what your obligations are going forward unless or until this new legislation. And then if there's new legislation, there'll be a notice provision in that law that also will go out individually. As to the interim orders, we're not able to send the individual notices because the state isn't functioning. And so that information will go out via the state police website, the ACLU website, and there'll also be copies of the order that go to every prosecutor's office in the state and every police chief or sheriff in the state for wide distribution in that way.
There's a couple questions about the new bill about 5679, and I'm just going to confirm, yes, it's bad. No, we're not going to support it. So we'll answer those questions on the website. So let's see, when do we anticipate having a new law? I think Paul went through all that. We're just, you know, it kind of depends on the pandemic.
Yeah, I should say on the new law, I mean, it's encouraging that the chair of the committee wants to have full hearings. We think it's educating the legislature and the public in the same way that it took a very long time for us to educate the judges about the harm that these statutes do. In my view, we won Doe's 1 and Doe's 2 not on the strength of the law, but on the strength of the factual record, when the judges understood that there were people on the registry who had never committed a sex offense, and there were people on the registry who had never been convicted of a crime, and there were people on the registry who couldn't go to their children's events in school, even though their crime was 30 years ago or 40 years ago or whatever. That was what was compelling. And so that's what we need the registry to be doing. I have to get rid of my dog, just a moment.
And so while he's gone, there's a lot of questions about whether people have to register right now, like do pre-211 currently have to register. MSP sent a memo out that they're not taking any verification from pre-2011 registrants, but again, there's been some, you know, not all the prosecutors agree with that. So, you know, I would suggest that you call and just try to get verification from your registering authority that they are not asking you to come in to register. So we also don't want you to go out in public right now. So to the extent you can get that information through a phone call, that's, I think, the best way to address it right now. And then there's a couple questions, Paul, about, you know, people who were sentenced before this whole law was put into place. This whole law is retroactive. So you want to talk about that a little bit?
Yes, that's I think the people with the oldest convictions have the best grievance, but unfortunately the law is what it is. You'd think that if the registry was not even in effect when someone committed a crime, how could it ever be applied to them? But unfortunately, if the registry is viewed as civil in nature, if it's viewed as monitoring, the state has great leeway to be able to add to the collateral consequences of someone's crime after the fact. The legal hook that we were able to use in Doe's 1 and 2 is the ex post facto clause. But in order to invoke it, the level of state intervention has to be onerous enough and burdensome enough and harmful enough that it rises to the level of punishment, because the ex post facto clause says thou shalt not punish somebody after the fact. And so the people who have convictions from before 94, 95, whatever was the first registry, are in no different position from the people who were convicted from 95 to 2000 or 2000 to 2006 or 2000 to 2011. Once you have the conviction, unless the state intervention rises to the level of punishment, they can keep adding new restrictions. That's why, I mean, my own view is what's really going on is we simply pile on against people who have sex offenders, and it has nothing to do with recidivism rates, danger to the public, anything else. You know, that's what we've been arguing for years and years, because we know that these statutes don't do anything. And if anything, they make the public less safer, and they make the lives of all registrants much, much, much more difficult.
So Paul, one of the questions is if 5679, which is the bill that is introduced, it's not even close to being law. If it doesn't address the Cleveland ruling or address constitutional issues, how could it become law regardless of whether we fight it? So that's one question. I think I want to just add in here that it is if this bill did pass for some reason, I don't think we know if the governor would even sign it. So we're not even sure about that. But I wanted to say that before.
Right. The hope is that the governor would not, and the hope is that we can make, huge changes in it before we're talking about anything that's going to pass. But if it were to pass, it's not something that you can stop in advance. I mean, we know what's going to happen in the meantime. There'll be an injunction striking down SORA as to everybody pre-2011 until there's a new bill. The old bill will go, the old SORA will go forward, but for the vagueness, the strict liability, and the First Amendment issues as to everybody post-2011. But even the state police don't want there to be two different bills. I mean, it's hard enough to enforce a complex SORA as it is. And if you then have two different bills that law enforcement has to enforce, that's nuts. And I don't think anybody wants that. What's most important is what is the topic of this webinar, and that is getting people together to educate the legislature and the public in the next 3 or 4 months so that this bill can be defeated. One other point, some of the questions asked, do we have to wait until it's passed before we can attack it and file a new lawsuit? And the answer to that is probably yes. There might be an outside chance that if we saw it was about to be signed, that we could, in the current case, go into court and argue this is so similar to the old law, you should treat it as sort of a bad faith effort by the legislature to simply continue to do the same thing. That might have legs, might not. But usually when there's a change in the law, it means the current lawsuit is mooted and you have to bring a new one. This one, again, if we're the exact same bill, but for a few words, we might have a shot at an injunction through the current lawsuits.
There's a lot of people asking about verification still. Again, if the state police told you not to come and verify, then write that down and you don't have to go in until you get notice. Let's see. This is asking about the tier system, Paul. Can you remark on, because the tiering system wasn't strictly constitutional. Can you remark on how the judge looked at that?
It was the Sixth Circuit panel that said, I think for them, the tiering system was a significant part of what made them say, cumulatively, the 2006 and 2011 amendments rise to the level of punishment. And what concerned them about the tiering system is that so many people are on the registry and so many people are on the registry for life. I'll give you an example. If people coming out of prison now or going into prison now on a sex offense are subject to are given an instrument that is supposed to not calculate their individual risk, but place them in a risk category. And those kinds of instruments, when they're administered to a very large population, over time, 200,000, 300,000, 500,000 people, become fairly accurate predictors of, again, not individually, but as a class, as a group, which people are most likely to reoffend and therefore who pose the greatest risk to the public. But what we were able to show in the Doe's 1 case, in the factual record, was that when you use those instruments, 60%, 50-60% of the people are score as low risk, and maybe another 15%, maybe more, score as medium risk, and only a small percentage score as high risk. And yet the way SORNA and Michigan SORA are constructed, they treat people as if every person on the registry was the worst possible offender. You know, all of these statutes are named after someone, a child usually, who was abducted and raped and murdered. And the strictures that SORNA and in part SORA impose make it look as if everybody is that person. And I think that's part of what struck the Sixth Circuit, is you've got all these people, and there's no evidence in the social science research that the statutes do any good, that they make anybody any safer. And so the balancing that you're doing is, what is the harm to the class and what is the benefit to the state? And if the harm is extreme and the benefit is little, none, or maybe less than none, it might actually be doing harm. That's what motivated the court in the end, I think, to say these are punitive statutes.
Okay, but we've only got a few minutes left. So Paul, there's one thing people want to know is, what is the implications on any prospective law due to people be Betts?
Betts is a case that's pending in the Michigan Supreme Court and has been for a while. Unlike the Doe's case, it's a single criminal appeal. It's someone who committed a sex offense now quite a while ago, took a direct appeal, lost in the Michigan Court of Appeals, and is now in the Michigan Supreme Court. The outcome of the case, in theory, should only affect him, but the court has asked for very broad briefing, basically covering all of the same issues that the Sixth Circuit decided. It did that probably because, although the Sixth Circuit is a federal appellate court, technically it's applying federal law, and its decisions don't bind Michigan courts. And so the Michigan Supreme Court may want all this briefing and may decide the case so that there is a binding Michigan Supreme Court decision on the same issue. It's a little risky for us because you could wind up with conflicting decisions. They might say, we disagree with the Sixth Circuit and the law's not so bad. They might say we disagree with the Sixth Circuit and we think even the amendments before 2006 rose to the level of punishment. And so we're gonna wipe out even more of the statute. The briefs in Betts were due a few months ago. The argument in Betts was supposed to take place on April 1st. And for the same reason that Doe's 2 has been held in abeyance, Betts has also been held in abeyance. And at this point, I don't think we expect there to be an argument until the COVID-19 crisis is over, or it looks like we're coming out of the woods. And that will be probably several months away.
Paul, could you talk a little bit about the offense date, conviction date problem that we face in these and making these determinations?
Yes, there's sometimes confusion with the ex post facto clause about whether the operative date for whether you're within the class or not is the conviction date or the registration, the commission date or of the crime, or the conviction date. And if you understand the theory, the answer is easy. The theory with the ex post facto clause is that at the time you commit a crime, you ought to know what the punishment is. It shouldn't be that you commit a crime. You know, it's like if they say, if you rob a party store, you're going to get 20 to 40. You rob the party store, and the next day they pass a new law that says, oh no, it's going to be 40 to 60. You get to say, geez, if I known it was 40 to 60, I wouldn't have done it, you know? And that's how the theory works. And so it's the commission of the crime date that matters for the ex post facto clause, which makes sense because sometimes the conviction date may not be until years later, but it's what you thought the punishment was going to be when the crime was committed. So that's the operative date.
So we only have a few minutes left, and there are a number of questions. So a couple of things. We're going to get all of the questions both from the Q&A and from the chat, and we'll type the answers to them and put them on the website. A lot of people are asking, you know, how they can be involved. Please feel free to also contact any of the panelists, but the intern at ACLU Mish website is where you want to send that stuff. And then Paul, there have been a couple questions on, you know, what do you think about the constitutionality of 5679? And you may or may not want to go into that, but there were a couple questions.
I'm always anxious about talking legal strategy, future legal strategy in a forum that's public. I will say, I'll echo what Shelley, you have said, and that is that we think the bill is atrocious, and our legal position is that it's unconstitutional, and in its current form, I believe the ACLU would challenge it. I just think, in light of when we were negotiating with the state, the players who were negotiating included people from the Department of Corrections, the Prosecutors Association, the state police, the legislature, the governor's office, victims' rights groups, the plaintiffs on behalf of registrants. The negotiations involved 20 to 25 people meeting on a weekly basis. And there was a lot of agreement in the room about not to put too fine a point on it, but the stupidity of the current SORA. The amount of federal money that we get by having a SORNA compliant SORA is minuscule. It's like $500,000. But the amount of money the state spends to police 44,000 people, most of whom are never going to commit another offense, is mind-boggling. It's millions and millions of dollars. My conclusion was that all that SORA really does is create a mill of violations where you wind up sending people, sometimes because they were homeless or because they were sick or because they forgot or whatever, to jails and prisons. There were thousands and thousands and thousands of misdemeanor and felony convictions from the early 2000s until today. And what you're doing is every time you do that, you have all the costs of the police, and then the courts for the prosecution, and then the prisons and the jails. And what do you gain from it? Nothing, if all of these people were never dangerous, or the great majority of them were never dangerous to begin with. You're spending money for something that doesn't work and is insane. And as long as you have a public registry, you're harming the people, because that's the first thing that everybody in the world knows about.
So I'm going to throw one more question at Paul, but before I do, I'm going to just thank everybody for joining us. Jessica, I hope you have all that information up on the screen, or so that people can call and text and reach the people on the panel. And I'm sorry we don't have more time to answer these questions, but we will, like I said, we'll have them on our website, and we'll figure out how we can, and this will be recorded and on our website as well. The last question, Paul, and perhaps you can, we get this a lot, is how there seems to be some confusion that Judge Cleland has some control or some ability to throw out a law, that, like the proposed law, for instance. Could you talk to people about what the judge's role is in terms of the legislative?
The defendants in the case are the governor and the director of the state police. And those are executive offices. What the court can do is say, I am enjoining enforcement of this statute, and in effect, making the statute non-existent for the pre-2011 people if there's not a new law passed. That's the extent of his powers over the law. You know, there could come a point, I suppose, where if people were still enforcing the law, they could be held in contempt, or maybe the state could be fined, you know, something like that. But he can't rewrite the law, and he can't edit the law that the legislature writes. As I said before, there might be an argument that if the legislature in bad faith passed almost the same law, we might be able to get the judge to say, you know, I'm willing to look at that law in this case rather than in a new case. it wouldn't be hard to make the new case, right? We would simply, recruit the same plaintiffs and file virtually the same action shortly after the new bill takes effect, if it's that bad. But I think that answers the question.
So that's all the time we have. I thank everybody for joining. Thank you, panel, for working with us. We really look forward to putting this campaign together. So we've got your answers from the poll. You've got information to contact us, and we will follow up with you. Thank you so much, and everyone, I hope you're safe and as well as you can be. Take
Shelley,
care.
if we get the new order briefly, is there a way to send it to the people who are on the webinar?
Jessica, can you answer that question?
There sure is. As soon as we have anything, we can email out again the link to where we will be placing all of the questions and answers we could not
Great.
answer, and then any updates on a new order.
Okay, thank you. All right,
Thank you. Thank you, everyone.
bye-bye.